in labor dispute. As we know that Ministry of Labor officials and respective state labor department officer also act as a conciliator, as a conciliation officer in the labor dispute. They are also a statutory authority under Minimum Wages Act, Payment of Wages Act, Payment of Gratuity Act, Equal Remuneration Act, Maternity Benefit Act, Employee Compensation Act, etc. And basically they are following the principle of natural justice. Here the other side also. No man is judge in his own case. Labor officials resolves dispute on the principle of natural justice and respective labor statute. Labor Act are self-contained act. Provisions are prescribed under the act. Under the Employee Compensation Act, what action Deputy Labor Commissioner has to do to settle the dispute between concerned employee and management. Regional Labor Commissioner or Deputy Labor Commissioner will decide the minimum wages case and payment of wages case as per Minimum Wages Act 1948 and Payment of Wages Act 1936. The cases under gratuity is also decided as per Payment of Gratuity Act 1972, and same is applicable in Equal Remuneration Act also. Today I have to discuss about Industrial Dispute Act 1947, in which there is mechanism established under the Industrial Dispute Act for congenial business environment and industrial peace. Under the Industrial Dispute Act, there is Conciliation Officer, Work Committee, Board of Conciliation, Labor Court and Industrial Tribunal. They perform various activities to resolve the dispute between workmen and management. Under Industrial Dispute Act, Section 3 speaks about Work Committee, in which there is representation of worker and management, and they sit together and resolve the problem raised by the workmen concerned. There is provision of Conciliation Officer who is appointed by the government. Under Section 4, Conciliation Officer, the appropriate government may by notification in the official gazette appoint such number of persons as is think fit to be Conciliation Officer, charged with the duty of mediating in and promoting the settlement of industrial dispute. A Conciliation Officer may be appointed for a specified area or for a specified industry in a specified area or for one or more specified industry and either permanently or for a limited period. Under Section 5, Board of Conciliation, but it is no existence as per my knowledge. There is provision of Court of Inquiry under Section 6. There is provision of Labour Court under Section 7. 7A Industrial Tribunal. Section 12, Section 12, there is discussion of role of Conciliation Officer, duties of Conciliation Officer. Where any industrial dispute exists or is apprehended, the Conciliation Officer may, or where the dispute relates to a public utility service and a notice under Section 22 has been given, shall hold conciliation proceeding in the prescribed manner. We can know the duties of Conciliation Officer under Section 12 in details. Basically, if there is any case of a strike and lockout in public utility service, Conciliation Officer send notice to both management and union and try to resolve the issue. Conciliation Officer also suggest, advise and take proactive action. He suggests various options so that both management and union try to reach a point which is win-win for both the party. There is other dispute also, sub-right dispute, if the workman is retrenched, terminated, discharged, dismissal. In this case also, Conciliation Officer conciliates between management and worker. There is interest dispute in which Conciliation Officer conciliates between union and management regarding bonus, wages, incentive, other facilities. Conciliation Officer basically advise, suggest, intervene, act as a guide of both management and union. But it is management and union, they have to decide. The actual decision maker, then actual determination is with the union and concerned management. Conciliation Officer only gives them various options so that there is establishment of peace and harmony in the industrial sector. As we also know that conciliation provision is also under Arbitration and Conciliation Act under Section 61 and from 61 to Section 6081. In the Arbitration and Conciliation Act also, conciliator is appointed by the consent of parties and by the institution which the party requests. In the Industrial Dispute Act, Conciliation Officer is appointed by the government, but the role of conciliator is neutral here also. In Industrial Dispute Act also, conciliator officer participation by a third party. Conciliator officer plays a role of third party in a dispute between management and its employee in order to bring them together to resolve their difference is termed mediation or conciliation. A conciliator has no authority or power over the party to force them to agree. He merely offers his service and seeks through his good office to find an answer that will meet the need of the two parties. He does not take side in the dispute. He may suggest answer to the problem. He may seek to persuade the party that his proposal are reasonable and workable, but he must not force his suggestion on them. The party must be convinced and must voluntarily work out the answer. It should be made clear to the party that proposals suggested by the conciliator are for discussion purpose only. They must not be taken as the conciliator position on the issue, but merely his draft of something which he thinks the party might be willing to accept as reasonable and might amend to meet their needs. The conciliation officer should be well informed and should offer assistance and guidance to the party on matter of law as well as fact. Where he does not have the information, he should be able to obtain it from the party. The conciliation officer must not let his own feeling about the problem limit his effort to find a workable solution. He may point out that all relevant document, fact, and figure have not been furnished and ask for further documents. Conciliation officer has power to extract information and document from the party. He has power to demand any document and any related paper which is related to the dispute, so that he may understand the dispute. He has also power to summon party if they are not appearing before him. He may summon the party, and these rights are given to him under Industrial Dispute Act. Situation may arise talking to want his opinion on the merit of the any party wants should give him advice, but he should not lose his neutrality. He should maintain his neutrality as a conciliation officer. The conciliation officer act as a guide to both the party. Under Industrial Dispute Act, alternative dispute resolution in this Industrial Dispute Act, there is mechanism through which party can settle their dispute and they have not to go to litigation. The party can save their time and money, and it is a very good mechanism so that industrial peace and harmony may be created, can be created in the industrial sector. And in the last, I can say that under Labor Statute, particularly Industrial Dispute Act, Employee Compensation Act and other labor acts, the officials are working under the respective statute. They are performing their work as per Labor Statute, as per Self-Contained Act like Minimum Wages Act, Payment of Wages Act, Equal Remuneration Act, etc. Thank you. I have tried my best. Thanks.